What I have for you today is a follow-up on a case that we have discussed before about the revenue rule, and I will put a link to that case down below. Now, this case concerned the so-called Danish and also German cum-ex cases, where entities and people who were not holding shares in German and Danish companies claimed refunds of dividend withholding tax on dividends that were paid on these shares, but never to these individuals because they never owned the shares. And part of the individual's defense afterwards were that they had no idea that it was wrong to ask for refunds from dividend withholding tax for shares you never held and dividends you never received. It is interesting to look at this case because we do not hear about the revenue rule very much. It is something akin to sovereign immunity, in the sense that one country will not exercise another country's tax laws and will not allow those laws to be exercised on its territory. And the same case has been decided by 3 different courts. The first case is the UK Supreme Court, and we will look at that decision in depth. Then the same issue happened also because there were New York pension funds that participated in the scheme, so it was also decided before the New York District Court, and we'll look at parts of that decision. And then the case was decided in the Malaysian Court of Appeal. Now, I could not find the Malaysian original decision, and publishers took too long to respond, so we will refer to the case, but I do not have the actual decision for you. So let's see what was going on in these cases. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. When we look at the UK Supreme Court decision, it starts by describing the revenue rule, and it refers to the landmark case in which it says the editors of the Dicey, Morris and Collins State, also discussed in my previous video, state that there is a well-established and almost universal principle that courts of one country will not enforce the penal or revenue laws of another country. And you get direct and indirect enforcement. Direct enforcement occurs when a foreign state or its nominee seeks to obtain money or property or other relief in reliance on the foreign rule in question. And indirect enforcement occurs when the foreign state in form seeks the remedy not based on foreign rule in question, but which in substance is designed to give extraterritorial effect, or where the private party raises a defense on foreign law to vindicate or assert the right of the foreign state. So again, you cannot use foreign states to apply your laws and enforce your laws in another country because your laws do not apply in the other country, right? So the court goes on to say, however, the rule does not prevent recognition of a foreign law of the type in question, and where direct or indirect enforcement does not arise, a foreign law of this type will be recognized if it is relevant to the issue and provided it is not contrary to public policy. The revenue rule is furthermore subject to exceptions where there exists a contrary agreement by treaty. Right. So what the court says here, and this is one of the big differentiations in this case, is, one thing is to enforce a foreign law, and we will not do that. But we can recognize a foreign law, we can look at what it says, and we can then apply our own laws accordingly, right? So, and that is what the court says it does here. And it also addresses the issue of what about a treaty? Because think of Article 27 of the OECD Monetary Convention that deals with assistance in tax collection, which is effectively enforcement of foreign tax laws, right? But that has been agreed under a bilateral treaty. It is not something that just pops up on in national law. The court goes on to say a complete answer to the appellant's objection under the revenue rule to the admissibility of this claim is provided by the fact that there are no taxes due from the appellants. This essential requirement for the application of the revenue rule is missing. And what happened here, remember, these defendants never held any shares, never received any dividends. The only thing they did was they requested dividend withholding tax allegedly withheld from them, but it never was, and that's the fraudulent part of the issue, which means that this is a variation of theft. It is not a tax issue. The court says it very well later. It says it was common ground before us that where the revenue rule otherwise applies, fraud does not itself remove a claim from operation of the revenue rule, right? So there are frauds that can be covered by the revenue rule. A claim to recover a tax which has been fraudulently evaded would fall within the revenue rule. However, in the present case, there was no fraudulent evasion of tax because the applicants for refunds never were taxpayers. The present claim for damage and restitution lacks the character of a charge of a foreign state pursuant to its tax laws. It is rather a claim founded on the appellant's liability for their own wrongdoing. Furthermore, it is significant that the claim does not rely on any Danish legislation as giving rise to the obligation to pay. The claim is put on the basis of common law, so English law, causes of action in English law. An alternative case is advanced on the basis of Danish private law, and that's before Danish courts, but that's still not a tax issue. These private law causes of action in English or Danish law are enjoyed by all legal and natural persons. There is no question of Denmark invoking foreign rights here, right? The matter is summed up admirably by the Chancellor of the Court of Appeal. Remember, this case went through the Court of First Instance, which I believe we discussed. Then it went through the Court of Appeal, and now it is before the Supreme Court. And what the Chancellor says is, whilst because it was induced to do what it did by fraud, SCAT thought it was making repayments or refunds to the solo, etc. applicants, so these are all the defendants, they were not in fact repayments or refunds at all, but abstraction of monies by fraudsters, in the same way as if they had broken into SCAT's safe and stolen the monies. So what the court says here, and I really love the comparison, is, this has never been a taxpayer that evaded tax or did anything like that. This is simply a fraudster stealing money, and it does it in the form of claiming refunds, which it never was entitled to, instead of going into your bank and taking money out, which it never was entitled to either, right? By contrast, in the present case, the court goes on to say no tax is or was ever due, unpaid or evaded. The Danish tax system simply provided that context for the fraud. For the reasons given above, the revenue rule is inapplicable. So the defendants lose this and SCAT wins on this one before the Supreme Court. The Supreme Court goes on and also addresses some further issues. It says, finally, it is necessary to say something about a further submission on behalf of the appellant. So these are the defenders, right? Asking why Denmark did not rely on EU Council Directive 2010-24 EU concerning mutual assistance for the recovery of claims relating to taxes and duties, or the Convention of Mutual Administrative Assistance in Tax Matter from 2011, or the UK-Danish Tax Convention, because these are legitimate questions. I mean, there are these treaties in place. Why do you come to a private law claim on fraud, and why don't you use the treaty instead, right? And then the UK court answers the question by saying the short answer is that these international instruments are of no relevance to the issues of this court that has to decide. First, as Judge Kaplan observed in response to a similar submission in SCAT refund scheme litigation, the US-Denmark Treaty and its provisions for assistance on the collection of revenue are irrelevant because the plaintiff's claim do not seek to collect tax owed by the defendants and covered by the treaty. Secondly, the purpose of the international agreements is to assist states to recover sums due by conferring additional powers. They do not impose barriers to other means of recovery. So the fact that you have an Article 27 in the treaty doesn't mean that you must use it. You can use something else if it works better, right? But the core argument remains that since these defendants never were shareholders, never received dividends, the refund of the dividend withholding tax doesn't bring them into the treaty. This is not a tax issue, this is a fraud issue, and that is what the court is dealing with. And then if we look at what the New York court says, it does something similar, right? It analyzes the cases and says, as noted, the revenue rule prohibits courts from hearing claims by foreign sovereigns that seek direct or indirect enforcement of their tax laws. We've already seen what direct and indirect enforcement is, right? Its purpose is to ensure respect for sovereignty by keeping courts out of the business of adjudicating and enforcing foreign states' tax laws that embody their moral or political choices. The rule will also serve separation of powers by carving out from courts' jurisdictions disputes regarding extraterritorial tax enforcement which can implicate foreign relations and are better left to political branch of government. And this is something that weighed pretty heavy before the New York court, less so before the UK courts, although it has been mentioned in Dicey as one of the reasons why the revenue rule exists. And this basically says diplomatic relations between countries can be complicated enough, and we better leave that for the governments and the politicians to deal with. You cannot have courts mingling in and deciding on these issues on top of everything, right? I mean, one country might have different perspective on human rights than another country, or property rights, or anything like that, and then you can't have the court mingling in that. That is for the political powers to decide, and the political policy to be running this. And then the New York court talks about direct enforcement. It says CAT responds that the rule does not bar the actions because they do not seek unpaid taxes. They seek to recover for what amounted to theft, which the revenue rule does not protect. These actions plainly do not seek direct enforcement of Danish tax law. The defendants attempt to frame them as seeking to recover lost tax revenue when the only reason the money was lost is because the defendants in effect allegedly stole it. And the only reason it supposedly concerns tax revenue is because the defendant's alleged victim was the Danish tax authority, is too clever by half. And now, for those who are not English mother tongue speakers, too clever by half means it is more clever than it should be. You are overconfident here. And then the defendants in the US case raise another interesting, irrelevant point. They focus very much on saying, yeah, but they could have had the beneficial ownership of the shares. And if you look at the German cum-ex description that we showed in the beginning, then you can see a little bit where there might be some stock lending involved or not. And I think what they latch onto is they say, we could have lent the stock, whereby we could have been beneficial ownerships, but the court does not really follow them in the argument. The New York court says the defendant argue in the alternative that actions seek indirect enforcement of Danish tax law because the court will be obliged to determine whether the defendants owned the shares in a Danish corporation from which they claim to have received dividends. The determination which defendants contend would require the court to examine, interpret, and potentially enforce Danish law. The argument has three prongs. One, the issue of ownership is one of beneficial ownership. Two, the court must decide whether defendants owned the shares by analyzing and interpreting and applying Danish company law and tax law. And engaging in such analysis would constitute enforcement of Danish tax law and is precisely the type of meddling in foreign affairs that the revenue rule forbids. Now what was interesting, there's a huge list of defendants in the New York cases with a whole number of attorney firms, etc., etc. And they really pulled all stops and came up with all kinds of imaginative, let's call it diplomatically creative arguments, but the court has none of it. And the court goes on to say whether and how Danish law is relevant to beneficial ownership. Why should this be decided under Danish law is what the court says. It says, there is nothing in the complaints indicating that the defendants owned the shares at issue at one point, but not another. Likewise, the defendants do not allege that they in fact owned the shares at one point in time and have introduced no evidence to that effect, right? And there are two additional problems. First, the defendant's insistence that beneficial ownership must and will be decided under Danish law does not make it so. You might wish it to be so, but that doesn't make it the truth. With respect to the issues of foreign law properly noticed under Rule 44.1, the responsibility to correctly identify and apply relevant provisions of foreign law is that of the court. So what the judge says here is, don't tell me what to do. I will do my job as I see fit, right? And while the court is free to engage in its own research and consider any relevant material thus found, it is not required, this is killing, it is not required and does not propose to do the defendant's homework for them and scour Danish tax law for a provision that may or may not entitle the defendants to dismissal on this motion. I would be deeply ashamed if I was the defense attorneys to have a judge throw this at me. The court goes on to say the claims as pleaded are not ones for tax revenue, but for money stolen from the plaintiff by fraud. Mere recognition or even application of foreign tax law is not the same as enforcement. And we again get the same thing that we saw before the Supreme Court in the UK. It's one thing to enforce a foreign law. It is another thing to simply recognize it for as far as relevant in the claim before the UK court under UK law, right? Or in the New York court under New York law. The conclusion of the New York court was the defendant's motion to dismiss the complaints is denied in all respect. And they had a whole list of other complaints, which we've not gone into here because I really want to look at the revenue ruling in this decision. And then finally, the Malaysian court, as I said, unfortunately, the Malaysian publishers never responded on getting me a copy of the decision. But we can see here what the UK court says about it. And it says, Similarly, in Customs and Tax Administration of the Kingdom of Denmark versus Sailing Capital in Malaysia Jurisprudence 856, which concerned parallel proceedings brought in Malaysia by the respondent in the present appeal, the Court of Appeal, Putrajaya, I assume, addressing the substance of the pleaded case and the evidence filed, considered that the claim was an attempt to seek redress and remedies under the laws recognized by Malaysia, in particular the tort of deceit or fraudulent misrepresentation, and was not based on any debt accruing from taxes due and owing or tax evasion under the tax regime of Denmark. It observed that the claim did not arise from the tax regime of Denmark because the defendants never owned Danish shares and were therefore never within Danish tax regime to begin with. And that wraps up this case for us on the revenue rule. It's not something that you come across very often in international tax. It is a luxury to come across the same case in 3 different courts for us to look at. And it just reminds us that there are some other rules besides treaty rules that we need to pay attention to. I hope you enjoyed this case, and I look forward to discussing another one with you next time. Bye for now.